Welcome back, everyone, to another episode of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I'm the founder and CEO and also host of the podcast, Rich Lenkov. We're very privileged to have Alexander Rufus-Isaacs today to discuss some recent lawsuits alleging defamation, which Netflix and other streamers have settled. Alexander, welcome to the podcast.
Thank you very much, Rich. Appreciate the invite.
I do want to mention that you're a litigator with an emphasis on media, entertainment, and business disputes. You've handled many of these cases, some of which we'll discuss today. You're co-founder of Rufus-Isaacs. You're president of the Beverly Hills Bar Association for the current year. You've also been selected as a super lawyer by Southern California Super Lawyer Magazine and as Lawyer of the Year for Copyright in 2023 in LA by Best Lawyers. So, Rufus, recently in June, Linda Fairstein, who is depicted in the recent Netflix drama involving the Central Park Five, settled a lawsuit with Netflix in which she alleged that she was defamed, she was erroneously portrayed in various ways. She settled that lawsuit after several years of litigation. Notably in this, Netflix agreed as part of the settlement not to pay her anything, by the way. They were going to make a $1 million donation to the Innocence Project, but this was the first time that Netflix has agreed to add a disclaimer after the fact. So tell us, first of all, why this lawsuit got to the point where it did, and what were the issues central to this piece of litigation?
Let me start up by saying this, is I think the Linda Fairstein case was a tough case to bring from a jury perspective, because Ms. Fairstein did play a very active part in the prosecution of the Central Park Five, and she was unrepentant even when it was revealed that these 5 kids who were convicted were all completely innocent. So I think there would have been, she would have had a tough time getting any sympathy from the jury. But from a point of view of legal principles, she had a solid case, because the program makers showed her doing things and saying things that reflected very poorly on her, which were proven she did not do or say. And as a result, that is classic libel.
And very notably, they used her name, right? And rather than come up with a fictionalized name, which these kind of dramas frequently do for this reason, to avoid this kind of litigation, they used her real name. That was part of the problem, of course, right? Explain that.
Well, I think, this is a very fact-based docudrama. And because she was somewhat notorious, I can understand from the program maker's point of view that they were probably reluctant to put a fictional character in there. They chose to use her real name. They chose to cast an actress who looked very much like her, and she was performing many of the functions that she did in real life. So there was never any question as to whether or not we were watching Linda Fairstein. The problem we have in docudramas is they're not documentaries, and therefore everybody knows that we are relying on we are really watching the filmmakers or the program makers' vision of what occurred. We're not watching the actual footage. So there is an understanding that there is a certain degree of artistic license involved here. And, obviously the program makers are going to want to make an entertaining program. But there are certain lines that they have to observe. And really what it comes down to is that if they are going to show somebody acting in a manner which reflects poorly on them, they either need to have factual support showing that this person did do or did say exactly what they're saying. Or if they can't do that, they need to disguise the person's identity. And that depends very much on, the nature of the program and the role of the particular individual as to whether or not you can use a fictitious person. But with Linda Fairstein, because she was so well known, it was probably difficult to consider using a fictional character in her place. But Eva DuVernay, who was the main showrunner on the file, did say that she was using Miss Fairstein as the symbol of a prosecution that was that went far too far, and basically, acted unethically. And that's fine. You can use somebody in that nature, but then you have to do only what they actually did or said. And Mr. Werner and the program makers went beyond that. And a number of defamatory statements were knocked out on motion to dismiss. 5 went forwards, and they all survived on summary judgment. The court found that there was adequate evidentiary support raising tribal issues of fact as to the falsity, as to the damage to reputation, and as to actual malice on all of those 5 statements. So that was a resounding win for the plaintiffs' lawyers, who did an exceptional job in this case.
So Alexander, explain to us how legally courts look at the line between fictionalized accounts or artistic license and actual facts. I mean, that's got to be a very difficult line to tread from both the filmmaker's perspective and from the insurer's perspective, right? We'll talk about insurance in a moment, but that's got to be difficult.
Well, there is a subset of libel called libel in fiction, and that applies strictly when, in its purest sense, when you have a purely fictional series. And for example, we bought a lawsuit a couple of years ago on behalf of a Georgian lady with the name of Nona Gaprandashvili, who was a legendary and groundbreaking chess player in the Soviet Union and around the world in the 1960s, and broke through a lot of barriers and is a marvelous woman, and I'm a huge fan of hers. But the series in which our suit arose from was called The Queen's Gambit. And The Queen's Gambit was pure fiction. It was about a fictional gal from the Midwest who became this chess prodigy and went on to challenge all the Soviet masters in the 1960s and wins this big tournament in Moscow. And it's a great series and it's very good entertainment, but it is pure fiction. But what happened is, in that situation, is that the program makers, the writer, I guess for authenticity purposes, inserted Nona's name into it, the name of a real person, and said something that was blatantly untrue, which essentially, without getting into the details, said she wasn't good enough to play men. She was a second-class chess player, which is completely untrue. She took on and beat many men, even at the highest levels, grandmasters, international grandmasters, and she was very upset about this. Now, why did they use her real name? I think it was a big mistake, and I think good risk management would have stopped that, because nobody really knows Nona's name. She's not a household name, except in Georgia, where she's a huge hero. So just make up a name. And what's interesting is that the screenwriter changed from the source novel, where they do mention Nona, changed a statement that was true, which is that she'd played all these men and many times before, and he changed it to make it look as if she was second class, to make this fictional heroine's role in taking on the chess masters look even more laudatory and impressive. And so he was manipulating the truth to try and, for dramatic purposes, which we all understand. But the loser in this was Nona, and he has damaged her reputation. And we beat their slap motion, and the case settled pending in front of the Ninth Circuit.
Does it matter the degree to which the subject, the plaintiff in these lawsuits, are well known? Is there a sliding scale or different standards for different types of plaintiffs? We know that there are, higher burdens to prove in defamation when you are a celebrity. Explain that process for us, if you don't mind.
The same distinction between public and private figure applies, but there's a requirement in libel called of and concerning, that the libelous statement has to be of and concerning the plaintiff. And if you name the plaintiff, like they did with Linda Fairstein, then it's not an issue. There are other cases where the name of the person and their identity has been disguised. I have another case for a gentleman who was a world record holder freediver, and a film was made about him, and which insinuated very heavily that he murdered his wife. Is completely untrue. And they did not use his real name. But because this gentleman's career was so unique, our argument is that anybody watching this film goes, that is I won't use the gentleman's name, but that is him. And so it's not enough to use a fictitious name. It helps. But the courts look at basically 11 factors to determine whether or not a fictional character, whether people would believe that the supposedly fictional character they're watching on a screen is actually a real person. And not everybody has to believe it's a real person, but just, a reasonable viewer might believe it. And there are, if I can put it up on the screen, there are 11 factors that the courts look at here. Give me 1 second. Let's hope I don't screw this up. Here we go. This is an extract from a treatise, which is the main treatise on defamation, called Smola's on Defamation. And it says, in determining whether a character in a fictional work is of and concerning the plaintiff's court, consider a broad range of factors. Okay, so these 11 aren't exclusive. Whether the plaintiff's name or a very similar name is used. Whether there are physical appearance similarities between the plaintiff and the character, and the baby reindeer case is a good example of that, where they used an actress who looked very much like Miss Harvey, the plaintiff in that case that has just been sued. Then you might ask yourself, why cast somebody who looks so much like the real person, particularly if you're using a fictitious name, unless you want people to believe that this is the person? So the age of the plaintiff, the character, whether there are similarities in geographic location and setting, similarities in occupation and career, relationships, whether the work as a whole is presented as fiction, whether there is a disclaimer. There are often these disclaimers in these fictional series. My view is that they are really of limited importance and interest. I mean, for example, in the Rachel Williams case, in which it features Inventing Anna, the series about the Russian fraudster, they have this rather amusing disclaimer saying, everything in this series is true except for the bits that aren't, which is completely ambiguous. It doesn't tell us, okay, some aspects, and it's a story of a real person who was convicted and she's identified, but it doesn't tell us which aspects of the story are real and which aren't. So the problem here, Rich, is that people basically believe when they're watching a program like that if they identify a person on the screen with a real person, obviously if they use a real name happens, they believe what they're watching is the actual truth. And therefore, if the program makers show this person doing things that are despicable, that reflects them in a poor light, then that person is a perfectly valid cause of action. The fact that it's fiction doesn't make any difference one way or the other. And the Gapran-Dashvili, and we have a case in California called Bindram back from the 70s, which has held that to be true. So this is not new. It's been around for a long time.
So to that point, it's been around a long time. These 11 factors that you just pulled up, they're not some secret, some secret file that's in your office. They're readily accessible. So given that, and given the amount of money involved and the likelihood of litigation, how are these instances still happening? Is it just shoddy, review of screenplays? Is it laziness? Is it poor legal, counsel? I mean, how is this still happening where studios, artists are exposing themselves to this type of liability?
And a very good question. And I definitively, I don't know the answer, but I will say this is my law firm, my old law firm. We used to do a lot of clearance work for major studios. And we used to take scripts and we used to go through them in detail, identifying every possible problem there, either from a copyright point of view or from a defamation or a privacy point of view, and bring these to the attention of the studio. And in those days, the studios were very risk averse and were willing to go and take out anything that we thought was risky. My feeling is that the popularity of crime-based and reality-based dramas these days are such that even though there must be people who are flagging these issues, I don't believe that their concerns are being listened to by executives. And I believe that the desire to sensationalize and to have successful programs and to attract more eyeballs outweighs the risks of potential lawsuits. And I think that's the current way of thinking, because these companies like Netflix, they still have clearance departments and, they must be doing something. So there must be some internal decision making rather along the lines of the Ford Pinto case, which is we realize that we could fix this problem if we wanted to, but perhaps it is, it's going to be more profitable for us to leave the product the way it is and just to deal with the claims as they come up. There may be, I'm not saying there is, but I'm saying there's a possibility that there may be some of that thinking in some of these cases with some of these companies.
That's Alexander Rufus-Isaacs. The law firm is Rufus-Isaacs, Ackland, and Grantham out of California. Website is rufuslaw.com. Thank you so much for joining us on the SERMAPod, Alexander.
Thank you. I am a recovering insurance lawyer, by the way. I spent many years defending Lloyd's of London, and I do consult from time to time to look at issues like this. I'm happy to do so. Thank you very much for the opportunity, Rich. I've enjoyed it a lot.
Appreciate it.